Trust instruments frequently contain detailed provisions governing the distribution of trust assets. But what if, because of a mistake, those terms fail to accurately reflect the settlor or trust creator's intent? In Agnes M. Gassmann Revocable Living Trust versus Reichert, we explore judicial reformation as a means of correcting such mistakes. Husband and wife John A. and Agnes Gassmann executed identical trusts, which we'll refer to as the parent trusts. The parent trusts, in turn, created 4 trusts, one for each of the couple's children, John T., Mary, Joanne, and James. Under the parent trust's terms, when John A. and Agnes died, the trust assets remaining after specific distributions were to be divided equally between the children's trusts. Before their deaths, John A. and Agnes created a partnership, the John Thomas Gassmann LLLP, to which they deeded certain farmland. Each parent trust held a 49.5% partnership interest, and John T., the partnership's namesake, and the person who farmed the land, held the remaining 1%. The specific distribution sections of the parent trusts stated that if John T. survived the settlor, then the trust's partnership interests were to be distributed, quote, to my trustee and successors in trust, to be handled pursuant to paragraph 2 of Article 10, unquote. That paragraph created the 4 children's trusts. Consequently, as written, the parent trusts required the partnership's distribution between the 4 children's trusts. But after John A. and Agnes died, John T. claimed that they intended the partnership interests to pass to his trust alone. Wells Fargo, as trustee, petitioned for an order clarifying and reforming the parent trust's terms. John T. testified that his father told him that he would receive the partnership farmland, and the attorney that drafted the trusts testified, based on recollection and meeting notes, that John A. and Agnes intended their partnership interests to pass to only John T.'s trust. The relevant distribution provision shouldn't have said that the partnership interests were to be distributed to, quote, my trustee, unquote, but instead to the trustee of John T.'s trust. Based on that evidence, the trial court concluded that clear and convincing evidence showed that a drafting mistake prevented the trust's terms from reflecting John A. and Agnes's intent. The trial court therefore reformed the distribution provision. The other 3 children appealed to the North Dakota Supreme Court.